Dear viewers, this lecture is devoted to fundamental rights as enshrined in the Constitution of India. Where these fundamental rights appear in the Constitution? They form the part 3 of the Indian Constitution, which deals from Article 12 to 35. Now, is in this part 3 from Article 12 to 35, fundamental rights are incorporated from Article 14 to 32. It means Article 12 and 13, Article 33, 34 and 35. They don't mention about fundamental rights, but some other things which are directly related to fundamental rights issue. So you have to remember two things here. Number one is that when question is asked about how many articles are there in fundamental rights, then you will have to write from Article 14 to 32. But when the question is related with articles of part 3, then you will have to write articles from 12 to 35. You just keep this thing in mind. Now I often tell to my students in the class even that whenever you read something or whenever you read some thinker, you cannot understand a thinker without understanding the context in which the thinker lived and wrote. Similarly, you cannot understand any concept, contemporary issue, without understanding the background of the concept. So it is very pertinent here, it's very important here. First of all, let me tell you, this lecture is very relevant for the students of political science, especially previous year MA students, and also very relevant for the students, those who are appearing for the competitive exams. It may be UGC or UPSC or any other state services examination. As I told you that I often tell to my students that to better understand a concept, you will have to go to the background. Now, what is the background of fundamental rights? This goes to the British history, 13th century history. 13th century England was ruled by King John II, and it is mentioned that King John II was a very brutal king. He imposed arbitrary taxes on the people, which amounted revolt against the kingdom. The revolt was led by barons. Barons were the feudal lords. You see, it was a hierarchical society. At the top of the hierarchy was king, then the barons, and then the common people. So barons revolted against the king, and this revolt ultimately settled down into a treaty, an agreement between the people and the king. And this agreement was known as Magna Carta. What is Magna Carta? Magna Carta is basically a Latin word which means Great Charter. In this charter, certain liberties and equalities were granted to the citizen. First was rule of law was established. If I pronounce it in Hindi, राज राजा का नहीं, राज कानून का होगा. So the king shedded his powers and he was brought under the ambit of the rule. Even king will be answerable to the rule, to the law of the land. Second was arbitrary punishments were banned. Third was even nobles, the kings and the local lords were also brought into the ambit of the law. Now, how from here, this concept was adopted in American Constitution. As we know that America was the first country who adopted a written constitution, and they incorporated these laws in their constitution titled as Bill of Rights. From Bill of Rights, when we started writing our constitution, we adopted this concept of fundamental rights from the Bill of Rights of American Constitution. Now, the question here arises is that why these rights? Why these rights are called fundamental? You see, fundamental is something without which that particular thing cannot grow. It cannot achieve its fullest. Anything which is fundamental to anything without having those foundational stones, nothing can be grown. So these rights are called fundamental because these are very basic to the foundation of human being. A man cannot achieve his fullest without these rights. To live a dignified life, man needs certain rights, and these rights are called fundamental rights. Now sometimes students get confused here. We have several type of rights: constitutional rights, fundamental rights, human rights. Or these are similar? All these are similar, or there is any difference? Yes, all constitutional rights are not fundamental rights. Like, we have right to vote, we have right to contest election, we have right to form associations, but these rights are not fundamental rights. The fundamental rights have some special characteristics. What are these characteristics? I will mention later on. The third category is human rights. Human rights evolved, as we know that human rights evolved after the formation of United Nations Organization in 1948. This concept was added in UN Charter. But all human rights are not fundamental rights. In India specifically, it depends on the interpretation of the Supreme Court of India or Judiciary of India, which human right belongs to fundamental rights. Now, the third important issue which I would like to mention before we go into the details of the fundamental rights: what is the nature and scope of fundamental rights? This is very crucial to know. Number one I would like to mention here is that, are these rights are absolute rights? No, these rights are not absolute rights. There are circumstances when these rights can be suspended or even eliminated, as we have done in case of right to property. These are not absolute rights. Dusra, very important thing is that are these rights are interconnected with each other, or they are separate in their own sphere? क्या ये एक दूसरे से जुड़े हुए हैं, या ये एक ही धारा के विभिन्न स्ट्रीम्स हैं? Are they connected? Yes. In fact, in this regard, Supreme Court has given contradictory verdicts. In case of a case happened in 1950, Supreme Court gave a verdict that all fundamental rights are separate from each other. But in case of Menka Gandhi versus Union of India, 1978, Supreme Court ruled, a 7-judge bench of Supreme Court ruled that these are interconnected rights. The effect of one directly affects the other fundamental rights. If you abrogate or if you eliminate one right, then it affects other rights also. They are interconnected rights. Now, the next important thing is, what are the basic characteristics of fundamental rights? Number one, these rights are different from other rights in the sense that these rights are enforceable rights in the court. They are basically backed by the force of law. If somebody, it simply means if somebody violates your rights, you can approach the court directly. You don't have to follow the set procedure of law. That means first you go to district court, then high court, and then Supreme Court. There is an article in Constitution of India, Article 20, which permits every citizen, if his fundamental rights are affected, he can directly approach to Supreme Court of India, and Supreme Court of India will listen and punish the violators. Second important characteristic is these rights are guaranteed rights. Guaranteed right means who gives the guarantee to these rights? It is the law of the land which gives guarantee to these rights. Now, what is the law of the land? It is the Constitution of India, obviously. It is our Constitution which is the supreme law of the land of India. It gives guarantee. Then who is the guarantor? Who protects? It is the judiciary. Judiciary is empowered with one very strong power, that is called judicial review. If any law violates fundamental rights, that law can be declared null and void. Next important characteristic, which is very important characteristics, is that these are not gifts of the state. You must remember this. These rights are not given by state. These rights are protected by state. Who gives these rights? As humans, we get these rights. See? So, without these rights, a human cannot achieve his best. To live a dignified life, nature has given certain rights. And these rights are fundamental rights. Okay? Then let us move to the second phase. I think everyone has grasped whatever I have said. I have tried to explain this thing on the board also. And the next portion of the lecture is devoted to classification of fundamental rights. Now, we are moving on the second part of this lecture, which deals with classification of fundamental rights. Now here, let us go back to the beginning. Here I would be explaining not only the fundamental rights, that is Article 14 to 32, but all the articles mentioned in Part 3 of the fundamental rights. Let us explain first Article 12. It begins with Article 12. Article 12 is a very significant article of fundamental rights which you should note down. It defines the term what is state. This is very crucial. What is, because this term state is repeatedly explained, it will appear in your readings. So how the Constitution defines state? State here means three things, my dear. You must keep in mind. Number one, central government, central legislature, and associated agencies. Number one. Number two, state legislative assemblies. The third part of Article 12 deals with local bodies. Local bodies, panchayats and municipalities, obviously. Now let us shift to Article 13. Article 13 basically defines what is law. It has 2-3 provisions. Provision 1, Article 13(1) deals with those laws which were framed in pre-constitutional history. Article 13(2) deals with post-constitutional laws. And Article 13(3) defines what is law. Now this is very crucial. What is the definition of law as provided by the Constitution of India? It says that any law framed by central government, state governments or local bodies, any order passed by these agencies, or even not even laws and rules, even customs prevailing. If there are customs prevailing which violates fundamental rights, even those rights will be declared null and void. Okay, so this is about Article 12 and 13. Now let us shift to the basic articles, fundamental articles, which starts from Article 14. The first article in this list is Article 14, which says right to equality. Total articles are incorporated in this article are from 14 to 18. Now, you can note down the definition of this. What Article 14 says? It says, state shall not deny to any person right to equality within the territory of India. Now, two things are very crucial. Number one, first, these are the directions to the state. Second, it mentions any person. It means this right, this fundamental right is available not only to citizens, even non-citizens, foreigners also. You should note down this. Any person, if any person is denied right to equality, whether it is citizen of India or a foreigner, then it is violation of right to equality. Now it mentions two very important things. One is equality before law, and the second is equal protection of law. Equality before law we have borrowed from British Constitution. This article is in negative connotation. Negative connotation means it prohibits the state from framing any law which violates the equality of the citizens. It is directly related to the British rule of law given by Dicey, as we know. Rule of law means the same thing. Raj raja ka nahi, Raj कानून का होगा. No one is above law. You must have seen in judicial complex or judicial courtrooms that there is a statue called binding a ribbon on the eyes. It simply conveys that in front of law, whether he is a king or a poor or anyone, law doesn't differentiate between them. Equal law for all. Now, the second part to right to equality is equal protection of law. It is different from the previous one, which says equality before law. It allows state or the state agencies to make reasonable classifications. You see, we all are not born equal. People have different capabilities, abilities. So all cannot be treated with same law. Now we shift to Article 15 of the Constitution. Article 15. The language of Article 15 clearly mentioned that not to discriminate against citizens only on the grounds of caste, religion, sex, race, and place of birth. This is very important to note down. The previous one, Article 14, mentions nowhere citizens. It mentions persons. It means right to equality is available to all, even foreigners. But this Article 15 is only available to the citizens of India. The second important thing is only. State cannot differentiate only on the grounds of caste, religion, sex, race, and place of birth. It means state can differentiate also, but it cannot differentiate only on these mentioned grounds. It has 3-4 implications I would like to mention here. Number one, these are directions to the state. State should not frame any law which differentiate among the citizens on the basis of caste, class, religion, and place of birth only. Second important thing is, these are directions to the state as well as citizens also. For example, private organizations, shops, medical shops owned by the private citizens. So even citizens are prohibited to make differentiation on the basis of the above mentioned reasons. The third important thing is it empowers the state to make special provisions for the children and women. You see, this is the meaning of, here comes the equal protection of law. We cannot treat everyone, all the people with the same stick. So it also empowers the state to make special provisions for the children and women. For example, children below 14 years are prohibited to work. Women have special provisions in our constitution. So this is all about Article 15, Article 14. Now we conclude these two articles. In this lecture we have completed two articles, Article 14 and Article 15, right to equality. At the outset, I would like to mention one thing, that these rights are not absolute rights. There are exceptions to them. For example, armed forces, medical practitioners. Secondly, the president and the governors of the states, they are exempted from arrest during their office. Similarly, MPs and MLAs, they cannot be questioned by the law during performing their duties in the state legislative assemblies or in parliament. So these are not absolute rights. There are exceptions. They can be suspended, as I mentioned in the beginning of the lecture. So here today we conclude the explanation of this, but the last and very significant portion of the lecture remains yet, that is about the questions. You will have to answer certain questions. So you may note down some important questions regarding this. Number one, mention those articles which are not included in the list of fundamental rights, but they are mentioned in part 3 of the Constitution. This is first question. I explained this in the beginning. And second question is, name the first written document on fundamental rights, and name the first written document on fundamental rights and the date also, on which date it was signed. Third important question is, which country first adopted Bill of Rights in the Constitution, in their Constitution? Which article enables the citizens to approach Supreme Court of India in violation of their rights? See, I mentioned in the lecture that there are certain provisions in Indian Constitution which empowers the citizens to approach judicial process directly, even Supreme Court of India, in violation of their rights. Do High Courts of India have power to express, to enforce fundamental rights, or it is the Supreme Court of India only? Which part of the Constitution of India called Magna Carta of India? So these are some of the questions you may face in competitive exams. Thank you very much for listening.